Hello and welcome to the Global Alliance for the Rights of Older People's webinar on access to justice. My name is Ken Bluestone. I'm chair of GAROP, and I'm standing in for Susan Summers, who is due to moderate this webinar, but will hopefully be able to join us shortly. I'm very pleased that you're able to be with us today. This webinar is part of a series to support civil society organizations to engage with the UN Open-Ended Working Group on Aging, including advocating with governments, with other stakeholders, and strengthening civil society to make direct contributions and participate in the process itself. The UN has opened its call for inputs for the next session, the 11th session of the Open-Ended Working Group. And the purpose of this webinar is to support you as civil society to prepare inputs to the areas on access to justice. This is a new area of rights that will be discussed at the 11th session. And any NGO that is accredited to the Open-Ended Working Group can submit their own responses directly to the UN. For those who are not accredited and are part of this call, this webinar, you can still inform and work with your governments to prepare their own inputs, and not just governments, but also work with human rights institutions. So we are very privileged today to have with us Bill Mitchell. Bill is a human rights lawyer and who's been practicing since 1992. He is a principal lawyer in the community legal service in Townsville. He's been awarded with the Australian Human Rights Commission Law Award in 2008 for promoting and advancing human rights in Australia, and was made an outstanding alumni of James Cook University in 2012. And he represents the National Association of Community Legal Centres at the Open-Ended Working Group since the 4th session. Bill is going to share with us a presentation about, so we can all understand better what we mean by access to justice for the rights of older persons. He'll speak for about 25 minutes or so, after which there'll be about 20 minutes for him being able to respond to questions that are coming through from yourselves. Please, we would request, if you do want to ask questions of Bill, use the question and answer, the Q&A function to ask questions. We will only be responding to questions that come through that function of the webinar software. Also, just a reminder that this webinar is being recorded and will be available on GAROP's website. So I'm going to hand over to Bill, and hopefully when he is finished, Susan will be able to join us and moderate the rest of this webinar. So Bill, over to you.
Thanks, Ken. I hope everyone can hear me okay. I'm coming to you live from the very northern tip of Australia. It's 9 p.m. here, and so welcome all. Just before I start, as is our practice in Australia, I'd like to acknowledge and pay my respects to any traditional owners of land. I pay my respects to their elders, past and present and emerging, as is our tradition in Australia, so thank you. And I pay my respects to any Indigenous persons on this webinar. Okay, so let's just make a start with these slides. So our purpose tonight is twofold. It's firstly important that you, members of civil society, understand about the right to access to justice, including its contemporary formulation, but also some key discussion aspects for older persons. And we will talk about both those things tonight. What is the right to access to justice, as well as how does it affect and ought to be formulated for older persons in society. Hopefully, if we can achieve that purpose, we will then assist you as members of civil society to actually prepare responses to the Open-Ended Working Group's call for inputs on the substantive issue of access to justice. You see a little red pencil down the bottom left-hand corner of the screen. That indicates on each slide that we're going to talk a little bit, or I'm going to raise with you, one of the guiding questions that has been released by the open-ended working group for input. And so they don't come at you in order tonight. So if you've got the sheet of guiding questions in front of you, they're going to be a little mixed up. And I've done that on purpose because as we progress through the webinar, we're going to deal with them as they become relevant rather than simply trying to work through them. So keep your eye out for these red pencils. They're going to appear. And each time they do, I want you to start thinking about how you might formulate your own response to this particular guiding question. So I don't want you to go away tonight and simply think, well, how can I address the guiding questions from what I've learnt tonight or what I understand from tonight's webinar? I want you to be thinking all the time, and particularly as we go tonight, how we might be formulating our own individual responses and how we might also contribute to a collective response of GAROP or the other various working groups you're involved in. That's our purpose tonight. So let's talk first about what is access to justice. They are essentially freestanding or collections of rights that guarantee equal access to an independent and impartial process. It's about the opportunity to get a fair trial when your liberty or your property is at stake. That's a little old-fashioned, that definition there, but it involves many different things, including judicial recourse or recourse to the courts or judges, but also the availability of other accessible and affordable and timely and effective means of redress and remedy. Importantly, access to justice has developed over time, but it wasn't actually explicitly formulated until the adoption of the Convention on the Rights of Persons with Disabilities. So whilst we've spoken about it and whilst it's been found in international law since the Declaration of Human Rights, it hasn't actually been seen in a clear normative content form until the CRPD. And we'll come to that formulation later on so you can see what that looks like. A few things we need to understand before we talk more about what access to justice actually is. Well, firstly, it's a cross-cutting right, and it's got to be understood and interpreted in that way. It's actually seen as part of and connected to many other types of rights and principles. So, for example, it needs to be understood as being part of and understood in line with equal recognition before the law. Access to justice is a right that actually enables and enhances other rights. So if you think about the right to health, well, the right to access to justice guarantees protections of that right to health through judicial and other administrative processes. So firstly, it's a right that guarantees other rights. But secondly, it also includes this very important concept of legal needs. They are different things, access to justice and legal needs. But when you come to practice, things seem to merge and the terms are actually very much related. So we don't need to worry too much about distinctions between these two concepts of access to justice on one hand, which is a right, and legal needs, which is, I guess, a form of analysis. We just need to understand they're part of the same bigger picture. It's a little complicated, but access to justice is sometimes expressed as a single freestanding right, but other times it's also a collection of freestanding rights. So depending on how it's been expressed and where it's been and where it is part of, it may not be a simple freestanding right. It may not be like simply in the CRPD at Article 13. It may be a collection of rights. So we need to understand that its expression has been different in different places and different times. Let's just talk about the global outlook about access to justice for a moment. The World Justice Project has estimated that 1.5 billion people cannot obtain justice for civil, administrative or criminal justice problems. 1.5 billion people. 4.5 billion people are excluded from the opportunities the law provides, including employment and housing. This is where we talk about it being a cross-cutting right. So the opportunities that the law or access to justice provides, such as employment and housing. There are estimated 253 million people who live in extreme conditions of injustice. But altogether, 5.1 billion people, 2/3 of the world's population, face at least one justice issue. And this brings us to the first guiding question. What do we have as existing provisions to guarantee legal assistance for older persons? What is the global outlook for older persons? In some ways, this question is, it might come at question 4, but in fact, it's almost the most important question because it's the question you have to start with. And of course, the answer is, really, there are no existing provisions that guarantee legal assistance for older persons in the way that other groups in society or other groups in the world have those guarantees. So that's our starting point. The global outlook is that 5.1 billion people have justice issues, and any of those who are older people or older persons do not have an existing guarantee. Well, what does that mean to not have access to justice? What is ineffective access to justice? The World Justice Project says that this means people cannot obtain justice for everyday civil, administrative or criminal problems, or they are excluded from the opportunities the law provides, or they live in extreme conditions of injustice. These 3 criteria are useful for you to come back to later, to ask yourself within your community and within your country or within your region, how can you express people's ineffective access to justice in accordance with these 3 criteria? I've given you a link down the bottom, which is the World Justice Project. These are general studies that apply to all persons. They're not only about older people. But these are 3 very useful criteria to look at in terms of the broader question of whether people can access justice, and in fact, whether they have ineffective access. So then what is effective access to justice? The OECD has done some very good work in this regard, and they say we've got to assess it against 3 components. And these are also components that you can build your submissions around. What is the nature and extent of unmet legal and justice needs within your community, within your country, within your region? What is the impact of those unmet needs on individuals, on the community, and on the state? And what do you know about effective models of legal assistance that can meet these needs? Effective access means at least 3 things, and I want you to pay particular attention to these 3 criteria. Again, they give you a wonderful basis for framing your submission. Firstly, effective access means empowering people and communities so they can act when a legal need arises. They are helped to understand the law and to find a solution. Secondly, access to justice is people-centred. So people have access to services that are responsive to their particular needs. But it's also about offering services that are less traditional and don't rely on more restrictive or complex or costly forms of justice, such as courts. So people-centred justice services include those that are what's called less adversarial or less like courts and more available to people in ordinary life. And thirdly, they give people fair outcomes. So people can actually get a resolution to their problem that is fair and meets human rights standards. Here we see another guiding question. It asks us, what are the provisions adopted to ensure effective access to justice for older persons on an equal basis? So we ask ourselves, against those criteria, we go back, are older people empowered within their communities? Do older people have access to older people-centred justice services? And thirdly, do older people get fair outcomes from their problems? There's an important relationship with the rule of law, and access to justice is a basic principle of that rule. Again, a guiding question that asks us, how are justice systems accountable? Are they independent and impartial? Are there oversight mechanisms to address discrimination against older persons? Can older persons have their voices heard? This is a part of the rule of law, and it's intricately linked to access to justice. Access to justice is also part of the development agenda, and the SDGs at Goal 16 actually prescribe 12 targets, and one of those targets is about ensuring access to justice for all. And I think it's very important that you make sure you address this issue in any submission you make, because it's important to establish that access to justice and human rights are complementary with the development agenda. They are not at opposite ends of the table. They are not alternative choices. They are complementary and they are linked. And access to justice is an excellent example of where a right is both a human right and part of the development agenda. And there's some good work being done on SD16. I've given you some links throughout this presentation. Of course, access to justice is useless without legal aid and legal assistance. And there are some guidelines and some standards, but I want you to think about what's happening in my community. What measures do we have in terms of providing legal aid or legal assistance? Don't concentrate only on criminal justice. Yes, it's a pressing issue, but what we know from the research is that older persons' problems are predominantly civil and family law problems. They are not criminal justice issues. We want to make sure that civil legal problems that are faced by older persons have the prominence they deserve and need. Let's look at a normative example, or an example of how the right to access to justice is reflected within international law. And we're looking at Article 13 of the Convention on the Rights of Persons with Disabilities. You can see there are 3 criteria: equality before the courts and a right to a fair trial, and the various points that flow below that, the right to an effective remedy, and participation in the administration of justice. I'll leave that on the screen just for a moment so you can just make sure you run your eyes over those 3 components of the right to access to justice that we find, or that is expected from Article 13 of the CRPD. The right is recognised in a range of international law sources and regional instruments and statements. We're going to run through those quickly now. It's in the Universal Declaration of Human Rights. It's also in the International Covenant on Civil and Political Rights, but it's also found in other conventions and declarations, such as the Declaration on the Rights of Indigenous Persons and the Convention on the Rights of Persons with Disability. So the right to access to justice is well recognised in international law. It's also recognised in the UN Principles for Older Persons, although it's a limited recognition. It talks about older persons having access to social and legal services to enhance their autonomy, protection and care. It is also underlying the principles of dignity at Principles 17 to 18. Again, this is a soft law approach. This isn't a binding approach, and so older persons haven't had the ability to enforce these rights in any meaningful way. It's recognised in a range of regional instruments, including the African Charter and the Inter-American Convention. It's also in various European human rights standards. So you might need to ask yourself, how is access to justice by older persons guaranteed under your regional arrangements? But go one step further and ask, are they working? Are they having the impact on older persons that older persons ought to expect? It's recognised in a range of statements and principles, and I won't labour these because you'll see these in the presentation when you can download it. And so there are a range of things that you might want to think about. One that's worth looking at is the OECD's Riga statement, which is investing in access to justice for all. This doesn't, again, have a particular involvement for older persons. It's a general statement, but it's a very contemporary statement. It was made just a year or so ago. So this is a good example of work that's being done by the OECD on the issue of access to justice. There are some specific examples for groups that include older persons, such as women's international law, but also some themes around housing and poverty. There's some legal needs research that's been done, particularly in Australia of all places. And there are some specific examples where access to justice rights might be different and might need some attention. I've given 3 examples there: the rights of older prisoners, the rights of access to justice contained in the Declaration on the Rights of Peasants, and the rights of Indigenous persons. Each of those is a group of older persons who have a very different experience of the justice system and access to justice. We ask ourselves, what steps have been taken to ensure access to justice for older persons in urban, rural and remote areas? And it's very important to reflect on the distinctions between those geographic locations of older persons. In Australia, the experience of people in urban centres is far removed from those in remote and rural areas. And that's the sort of focus we'll make in our submission about how there are differential access to justice issues in a big country like ours. You may have similar issues. Let's talk briefly about the obstacles and barriers that older persons face. Invisibility, a failure to recognise that crimes have a disproportionate impact on their independence, this idea of well-intentioned ageism or benevolent prejudice. So guiding question 9 is asking you to talk about What programs have been established for justice system personnel to address the negative impacts of ageism? Or how is ageism actually experienced in the justice system? And I think this is a very strong part of your submission to think about, quite aside from programs, how are older people's access to justice rights impacted by entrenched ageism within justice systems? Some other obstacles and barriers are lack of appropriate support, a lack of expertise, obviously fear of victimisation on the part of the older person and low self-esteem, but preconceived ideas about how older people are as litigants or witnesses. We also have a lack of expedition or delay in the justice system, which clearly is a problem for people getting towards the end of their life. We have the issues of social, digital and financial exclusion, financial disadvantage, inadequate social security and social protections obviously feeds into your access to justice rights if you can't afford to access the system. So guiding question 5 asks us, what are the specific challenges that older persons encounter in your country? What are the obstacles and barriers in your country? We've already talked about the time the legal process takes, but legal research analysis shows that older persons often find it difficult to identify when they have a legal problem. They have limited knowledge about their legal rights, and this knowledge gap has likely been made worse by digital disruption or their respective place on the digital continuum. The research tells us that solutions need to be based on data and they need to be evidence-based. They must be innovative and collaborative, focus on just outcomes, use technology as a tool, but within the context of older persons' use of technology, and also they must have sustainable financing. You must ask yourself in guiding question 6, what good practices are available? What solutions are available that we can point to in our country or in our region? Ask is the location of justice age-friendly in your country or region? And what steps have been taken to ensure that they are affordable and physically accessible for older persons? And are they also adapted to older persons' particular needs? I'm going to leave the normative content discussion for later. I've included this so you can see when you look back on these slides what sorts of suggestions might be made about what that content looks like, but remembering our inputs are about the substantive issues at this stage, so we don't need to get too stuck in the idea of normative content at this stage. The elements are, of course, like all normative contents, legal guarantees, non-discrimination, availability and accessibility, remedies and redress, and there's a particular issue for older prisoners. I've got some key sources there for you to look at. They are the ones that I've mentioned. There are others, and there'll be some discussion papers floating around soon that you'll have access to with more comprehensive references. But this is a great starting point. And that's all I have, so thank you. I'm just going to slip forward to a slide now as the final slide, which I'll leave up and I'll let the moderator come back in.
Ken Bluestone, and I'm just going to hopefully hand over to Susan to moderate the second part of this webinar.
Thank you, Ken, and thank you all and all who are participating in this important webinar. I'm Susan Summers, and I'm going to moderate the second half. Of course, thank you, Bill, for that wonderful So we have some questions. A question from Salish Mishra in the Silver Innings Foundation in Mumbai. Salish writes, why national human rights commissions are not part of the open-ended working group. All human rights commissions should submit their report of human rights of elders in their country. So how can we as civil society ask our governments to do this? So Bill, would you like to take that one?
Yes, look, Salesh, it is the case that national human rights institutions, or NHRIs as they're called, are part of the open-ended working group, and they are, as of the last 2 sessions, they have a place in that meeting. We're not seeing as many of them there as we'd like to, but every member of GAROP should be encouraging their Human Rights Commission to engage with the process, to send material and research they've already done, and to go along to the meeting. And certainly I spoke with our own age commissioner here a couple of months ago, and who's done some wonderful work on the right to work. And so I'm encouraging her to make sure that the Open-Ended Working Group has the benefit of that research. A lot of that research is looking at ageism and stereotypes within workplaces. And National Human Rights Commissions are exactly the sorts of places that have excellent research that would inform the working group. So that's an excellent question. Please, everyone, contact your Human Rights Commission, encourage them to get involved.
Well, thank you very much for that clarification that the Open-Ended Working Group now does include all national human rights commissions, which is a positive, and working with them in your particular country will help promote this. So we also have another sort of a clarifying question that came in from Patrick Harkness. You may have answered it, but I think for the benefit of all, we should discuss it. So he says, yes, he says, he was asking a question about the guiding principles that are mentioned in the first slide. And you did clarify that a bit, but perhaps you want to go back and make sure that we all have a handle on guiding principles that you mentioned.
Look, Patrick, my apologies if I'm not answering the question in the way that it might be expected. I think when we put together that slide, we were thinking about guiding principles from the perspective of, I guess, guiding normative principles. And we have a range of guiding principles around access to justice rights that are already entrenched in international law. But the actual formulation of those rights really has only occurred since CRPD. And so you see an alternate formulation in the Declaration on the Rights of Peasants. And so it is difficult to distill clear guiding principles from the mishmash of formulations. But I guess for us, the most important thing is to understand what are the guiding principles that older persons need in terms of access to justice rights. And I think, in fact, the UN principles for older persons, whilst they are a little dated and a little thin, I think their focus on autonomy and ageism is, in fact, still a very strong focus of how access to justice rights might be formulated for this group. But by all means, this is an open discussion and this is an open subject. And I think that the group will have to find its way in terms of what distinguishes older persons from other groups. And this has been a big part of the debate so far in the working group.
Well, thank you for that very comprehensive answer, Bill. But let me take a moment to remind the participants that there's a question and answer function in Zoom. It's very useful.
I think we've just lost Susan. I'm going to go back
and
to
you can type in any question.
I'm going to go back to the opening slide because people have asked that. I'm just going to go back to that slide. Sorry to have these slides flashing across the screen like this. Sorry, I'll just escape out. Okay, I presume that's the slide, and I think in fact, it's guiding questions that we're talking about, and the guiding questions are, of course, the guiding questions issued by the working group. I see that Francis has mentioned that the group has decided to rename itself, or it's been renamed. Can you hear me still, Susan?
I can hear you, Bill.
Yep.
Do I have?
I'll just read out that message. Francis Zinedin from, well, New York, I guess you'd say, but also from Australia. Hi, Francis. Or should I say good day, actually. Let everyone know that DISA has decided that from now on, the Open-Ended Working Group on Ageing will be called the General Assembly Open-Ended Working Group for the purpose of strengthening the protection of human rights of older persons. In an effort to make it clear about what the Open-Ended Working Group is about. It's a very long name. But thanks, Francis. That's I hadn't seen that or heard that, so that's a useful update. Back to you, Susan.
Okay, thanks, Bill. Thanks for that. And we have a question here from Betty Wong. She wanted to know if you could show slide first again, but you did. You've taken care of that. And if she wants further clarification, perhaps she could drop us another question. But we also had a question or two come in through the chat box, which Bridget Sleet of the Help Age International had sent a question. And she wanted to know how we could distinguish between the unique and particular barriers to accessing justice that older people face based on their age, their older age, from the barriers that the general population face. So could you give us a few examples or how that differentiation happens?
Sure, and I guess one of the problems we're grappling with is the limited amount of research that's been done around older persons' access to justice rights. There are some good examples of studies, and in fact Australia has some of that leading research, and I would point to the work done by the Law Council of Australia as well as the Law and Justice Foundation in Australia, who did some particular work around the legal needs of older persons as well as the legal information needs. Now that work is a little older now. I think it's probably 10 or so years old, and it needs to be updated. But there are very few examples of access to justice research done in this area. I'd like everyone to go away and look in within their own country's work and within their own jurisdictions to see if they can find this information. But typically the barriers that older persons face are about the types of legal matters they are experiencing, and so they are experiencing ageism on a whole range of levels. So ageism might impact their ability to be taken seriously by a lawyer. It might impact their ability to get to a courthouse. It might impact on their ability to be trusted as a witness or a person of credit. It might impact on their ability to afford a lawyer. It might impact on their ability through age discrimination in terms of them participating as a juror or working within the justice system. But it also comes out with a range of comprehensive thematic problems where they experience issues that are related to their autonomy and in particular their assertions of autonomy. So it's a very difficult question to answer quickly, but there is a very broad range of ways in which older persons experience access to justice, barriers that are not experienced by other groups.
Well, thank you again, Bill, for that. We have a bit of an optimistic question coming next. Erin Partridge asks, she said she's so glad that ageism was mentioned. In slide 21, obstacles and barriers, you mentioned well-intentioned ageism. And she says, should we assume that the working group will have a working definition of ageism, or will defining what ageism is in the context of justice be part of our work as NGOs and civil society? Great question. Bill?
That's a great question. Yeah, I think we all have a responsibility to contribute to the question of how ageism impacts on each of the rights that the working group is looking at. I know that the World Health Organization is going to produce a very comprehensive report on ageism, I think this year, and I'm very much looking forward to seeing that. I understand that it parallels the previous landmark report of theirs, the World Report on Aging. So that will no doubt draw together all of the threads of research. However, ageism is so intricately linked to every single human rights issue that the open-ended working group has looked at, I think it's one of the common threads that runs through all of the thematic issues. And so I see it as a framing element of a potential convention, just as autonomy, assertions of autonomy is a framing element, just as the very particular nuances of elder abuse are a framing element. Ageism is at the heart of it all, perhaps even more so than those other things. So a working definition, I think, could be very optimistic, Erin. I like your optimism. But if not a working definition, I think we have a golden thread throughout all of the debates we've been having, and that is ageism.
Well, thanks again for that, Bill. But Ellen Graham wanted, I think she'd like to answer this question herself. Ellen is at the Secretariat of GAROP, and if she's there, would you go ahead, Ellen?
Hi, Susan. I didn't want to answer the question myself. I was just marking it to be answered by Bill live. Thank you.
Thank you. Okay, now I'm just reading the icons, perhaps wrong. Well, thank you. So we have a follow-up question that goes with that to some extent, Bill. Mohan Adakati says to all panelists, do we have to make different plans to access to justice in older age on the basis of level of economy? You could discuss that perhaps?
Sorry, could you just repeat that one, Susan? I just missed the last part.
Yeah. Do we have to make different plans to access to justice in older age on the basis of the level of economy or our economic situations, perhaps?
Look, I think that's an excellent question, and one of the principal barriers to accessing justice is the cost of the legal system. And so, yes, our access to justice rights might say one thing, but the reality says another. So, it's an excellent way of bringing in the development agenda, SDG 16, and in fact the work done by the OECD, is focused on finding sustainable funding methods. And so I think if you can make submissions that draw upon older person-centered solutions to accessing justice that are that have a sustainable funding base, then they will be very well received. But having said that, I think we need to accept that access to justice is not a cheap right, because it is a cross-cutting right and because it supports so many other fundamental human rights. It hasn't been available to everyone. And so, yes, I think the economic aspects are something that certainly we will concentrate on, because I think they're a central barrier, if I can put it that way.
Thank you, Bill. And we have an interesting question from Lucy Vidakovia. She asks about older prisoners in her country. And so they're running a project on the needs of older prisoners, but they find it very difficult as the older prisoners themselves do not want to talk about age. So how do they empower the users to adopt that older person access to justice agenda is theirs? Do you have any skills?
I think the situation of older prisoners is a very special one. In my own experience, in working with older prisoners and older persons in the justice system who are offenders, I think we do need to have some specific focus on that position. They are a group who are possibly made even more invisible than others, and they are demonised more so than others. And they are, of course, without liberty in many cases. So, I think they're a special group. I think we should all focus on what solutions we know of that are very positive. There are some good access to justice examples for older prisoners. In my own state here, we have a prisoners' legal service. Now, whilst that isn't for only older prisoners, it does focus as much as it can on prisoners who are ageing in prison, because it realises they have a different set of needs than those who are moving through prison in a quicker period of time. So the people they call the lifers, who are there for life, who are ageing in prison, who have all of those ageing in place issues within a correctional facility, brings a range of very complex issues to the table. And I think if anyone on this conference has other experience in that regard, please include that in your submission. I think it's very important that the group hears about this incredibly vulnerable group of older persons' access to justice issues.
Well, thank you again. And I want to let you know that we've got several questions waiting, so perhaps we'll maybe try to do some of them a little more quickly so that we can answer more. I have one from Steve Bartley here, and he says he's in Wales, and they have a commissioner for older people, and the commissioner is the voice of older people there in Wales, with certain legal powers and to hold government organizations to account. So they've worked closely with them. There's a willingness by the organizations to improve justice outcomes. And they're the first in their country to have a commission there, and now also Northern Ireland Commissioner for Older. There's now an older Commissioner of Older Persons in Northern Ireland. But do you think that all countries should have a commissioner for older people?
Yes, in fact I do. And in fact, I won't get into a kind of Ashes test of age commissions here. I think the Australian Human Rights Commission claims that it was the first. But having said that, it doesn't really matter, because I think both the Welsh and the Northern Ireland and the Australian Age Commission really do provide a leadership role for national human rights institutions to have a dedicated commissioner to look at these issues and the sorts of research that these commissioners are producing. And thanks, Steve. I'm going to go and have a look at that. I'm going to go and have a look at that commission's website. I'm aware of the human rights document that was done in Wales. I've seen that some time back. But I think this is a great regional solution that we don't, you don't see all over the place. You see a few of them popping up, but there aren't many. So I think it's an excellent resource. And thanks for raising that. I'm going to go away and have a look at that. But I still think there might be only half a dozen of these dedicated age commissioners in the world. I don't think there's many more than that, but it's a great idea.
All right, now we've received two messages from Mayong Josh from GARP, K-A-R-P, in Seoul, Korea. And she tells us that older people in Korea suffer every day, and she thinks that this is a great opportunity to join with us and to work through the open-ended working group. But access to justice in older age is quite new working in Korea, though. So perhaps you could give her a little idea about how to get started, a good point to start from.
Yes, Mayong, I think one aspect of access to justice rights is it tends to be centred in countries that have a more traditional approach to the adversarial legal system. And my understanding of Korea is that it doesn't have as anywhere near the same heavy reliance on the justice system as we might in other countries. However, I think what's important to bear in mind is that the access to justice right really is about participation in justice. It's not just about accessing justice to resolve your own legal problems. It's also about being able to participate in the day-to-day mechanisms of justice. And they can be quite simple things, such as accessing legal information that tells you clearly about your other rights. As I said, it might be that the most important focus for someone from a place such as Korea is to look at how access to justice rights support people to know about and enforce their other rights. And this is, I guess, a really important part about the cross-cutting nature of access to justice. I know that some other people who've come to the group from Korea have talked about the very strong movement towards advanced care and end-of-life planning. And so I wonder if there's some access to justice issues around those legal and health issues in Korea. I'm not sure beyond that, but I think you need to think broadly about this, not just about this right to go to court. It's much broader than that. It's about participation.
Well, thank you for that. And with regards to South Korea, we do have a member of GAROP who has an NGO called Care Rights, which is an end-of-life NGO advocacy group. So you're bringing that up, Bill, was just perfect. It is the right time and the right place for that. Well, we have a couple more questions. Actually, we have a second question from Salish Mishra in Silver Innings Foundation in Mumbai. And he mentions that legal aid in India is not accessible. It has poor legal resources like lawyers, and many older people are not even aware of it. So what should we do?
Salesh, I think that this is a global problem, and many countries simply don't have access to legal aid in order to assist people to access justice. I guess if that's the case, then perhaps that is a very clear gap, and you can address those guiding questions which talk about what are the barriers that older persons face in accessing justice in India. Well, clearly, getting legal advice and accessing a lawyer is an important part of that. But it might also be a question of whether older persons have involvement in other forms of justice and remedies, such as local or tribal or traditional courts. Do they have trouble enforcing other rights they might need? For example, the right to access a social security payment. If that gets refused, well, how do they advocate for that to be corrected? Or perhaps the right to engage in some other form of participation. It might be the right to get healthcare or medicines. Again, I think where you don't have a big legal aid system, that is obviously one of the key parts of your submission, is that you can't access justice if you don't have the mechanisms to access it.
And coincidentally, Salish has a follow-up. And he wants to express the experience in India to get legal justice is just too long and troublesome. And you talked about timeliness.
Yes.
And lately, they have established some special tribunals, which you also talked about, elder courts and the design of those. And they have a district collector office, which deals with senior citizens, the Maintenance Act, and it's fast justice within a year. And this type of special tribunal or fast track court would be very useful. Do you have experience with that?
Look, I wish I could say that an advanced legal system like Australia had expeditious justice for older persons, but the simple fact of the matter is that we don't. This is a fundamental barrier for older persons because the research tells us that older persons will ask themselves, will I get a remedy? If the answer is, well, it will take 2 or 3 years or more, they just don't feel they have time for that. And so expedition or delay in court proceedings is a major barrier to older persons' access. So if you've got examples that are local examples of how expedition or how delay can be resolved, that's perfect. What you might also highlight, though, is if those examples are a compromise in some shape or form, and so they might be fast, but they might be maybe imperfect justice, then you should also highlight that as well. This is the very nature of administrative justice, which is balancing objects that are fast, efficient, and effective. And so you can't have all those things without spending quite a bit of money on it. So these examples are good, but you need to also highlight the limitations of those sorts of projects.
Well, Bill, I have a question for you now.
Sure.
And it's regarding alternative dispute settlement and to reduce the cost of access to justice and actually maybe make it accessible. And there's also a reconciliation type idea that some countries and some jurisdictions use. Could you talk a little bit about those types of access to justice issues or avenues?
Yeah, look, I think if I can tie that in with the notion that really the fundamental first point is that national laws need to recognise that discrimination on the basis of age is unlawful. So I think the starting point, or the first point really needs to be that national laws need to reflect the importance of non-discrimination on the basis of age, including within access to justice systems. The point you make about reconciliation and things like reconciliation commissions is very important generationally, because they can often deal with the trauma that a current older generation is experiencing. And there are some examples around the treatment of persons when they're younger that are now being resolved when they're older. And this includes things like royal commissions, truth and reconciliation commissions, and I guess inquiries into past traumas. So yes, these are very important things to recognise older persons' justice needs at this point in time. But I think a starting point has got to be a strong framework that has national laws that make clear that discrimination on the basis of age is unlawful. And I think access to justice rights often flow from that, even though access to justice rights aren't the most common area that is looked at. Obviously, things like work, health, social security are the ones that people tend to look at first, but access to justice rights are equally important and equally problematic from the perspective of ageism. So go back and look at your national laws or your local laws and see whether they give a guarantee of non-discrimination, and if that guarantee actually applies to access to justice. That's a great starting point. That's also one of the guiding questions.
Well, thank you. Great. We did have a question from Jack Kupferman in New York from the Grey Panthers. And Jack wanted us to think a little bit about specialists in elder law and related specialties, court administrators, government officials, and academics, and perhaps building their expertise and capacity as part of the access to justice overall approach.
Can I encourage people to contact their state or provincial law societies or peak bodies for legal professionals or legal academics, and ask them if they're going to get involved in this process, lobby them to get involved in this process. They are the people who know access to justice best. They may never have thought about access to justice for older persons. This may just be the opportunity they're looking for to say, hey, we've never done a project on this, and here's an opportunity to do that. So I'm talking with the Law Council of Australia about how the Australian legal profession is going to respond to this. Each of you go back to your own. You don't need to be a lawyer to talk to these bodies. You just need to raise the question with them and say, what are you doing about the access to justice rights from a professional perspective within this country? And maybe you get them involved, and maybe you get them thinking about the issues. Thanks, Jack. It's a great question.
And keeping right in line with that, Elizabeth Schlater from the UK with the Older Women's Network says that there's most of the difficulties about exercising our rights in other areas is the challenge of government, whether local or national, saying there are not enough resources. So how can we strengthen our rights in a way that we don't appear to be moaning minis?
Well, thanks, Elizabeth. I haven't heard the moaning mini before. Look, I think this is a point that has been very difficult for civil society to broach. The simple fact of the matter is that human rights cost money to implement, and this is one of the areas where it might not seem like it's a likely expensive human right, but in fact, access to justice mechanisms are expensive. Making them accessible means changing them from a very traditional, at least in the places we're in, you and I, Elizabeth, means really changing the very nature of these institutions. So I guess this is one of the reasons why the guiding questions asks not only how can we make traditional institutions of access to justice accessible, what are the alternative processes that don't need to be changed, but that are automatically or are alternatively providing access. And yeah, I think the resources argument is always going to be a problematic one. But again, we need to be strong and say to properly implement these rights will requires considerable work on the part of member states.
Mm-hmm.
I think there's any hiding from that.
We only have a few minutes left now, but we have 3 questions, and I'm going to combine 2. One from Mark Shizkanza, who asks, how can we accommodate older migrants, people aging while in transit? And Anita Rivers, So she wants to know what's being done to engage an intergenerational approach to create more visibility of the aging and more financial sustainability. So we have older migrants and then an intergenerational approach. Could you comment on that?
I think the older migrants question is a very good one, and I think that that warrants some particular attention in submissions. I think that older migrants have very specific set of access to justice issues around the right to be in a certain place, and I don't understand the complexities of this in the European continent. Obviously, it's made more complex by recent issues, but older migrants certainly face a specific set of concerns, and hopefully someone in civil society will be able to make some submissions. Obviously, the experience of older migrants has a whole range of issues around autonomy and identity that we need to try and flesh out a little more. I'm not even sure that I can answer that question, but I think it's an excellent theme that we need to make sure that we catch in our submissions, that particular group. And Anita, I think her question, I think an intergenerational approach is absolutely got to feature in every single submission that we make, because as we know, ageism really can only be resolved by taking an intergenerational approach. So yeah, I think it's one of those golden threads again. It's, you know, resolving intergenerational tensions is one way of resolving ageism, I guess.
Well, thank you. I know that we're very close to wrapping up here, but we have perhaps one question left. And you may have actually answered this. Bridget Sleep wrote in again from Help Age International, and she wanted us to mention something about the basis of human rights and discrimination. I'm sorry, I can't find her exact question now. Yeah, sorry. Yeah, the importance of having older persons' rights guaranteed in a national law. So you mentioned some other.
Yes, absolutely, and I think that's the starting point. I see also a question from Steve Robinson, and hi Steve. Your daughter's just graduated from law and she didn't do older persons' rights as a part of her law degree, and this is a part of the invisibility of older persons. They are not only invisible within our society settings, but they're invisible within institutions of power and those that create the powerful. And that, you know, you'll find a handful of universities, mostly in America, that teach older persons' rights as a part of curriculum. It's a great point that you make about this, and it's a similar point that was made about the importance of intergenerational work. Yeah, so thanks.
And we do have that last question from Fadover and from Bangladesh, and the barrier of older persons accessing justice in Bangladesh is the exclusion of the issue to the legal aid providers. So how can they sensitize legal aid providers to support victims of older women and men on the ground?
I think I probably don't have an answer for that. I think that national discrimination laws are one way to approach that. If you have a National Human Rights Commission, to ask them to investigate why providers are not providing an access on an equal basis to older persons who clearly have a need, if you're talking about older victims who are women. I think that the access to justice needs of older women is another area that we need to be keenly aware of. There's increasing research that talks about a whole suite of very serious access to justice needs, particularly those that reinforce older women's autonomy and safety, especially within institutional settings. So I think this is a question for your national human rights body or your provincial body. I'm hoping you have one. I don't know if the Bangladeshi Human Rights Commission, I don't know the extent of it, but I think this is obviously a national problem where you're seeing discrimination on the basis of age that should be raised with an institutional player.
Right. Well, thank you. And with that, I think that we're going to close the program shortly. We know that the voice of civil society and older people is making a difference and is convincing governments to support a new convention. So please take the conversation forward in your own countries, bring together human rights experts with older people and government representatives to discuss this area of human rights, to better understand how to protect the rights of older persons. And we want to point out that any organization that has ECOSOC status or that is accredited to the open-ended working group should respond to the call for input. And more information about this and the guiding questions will be available on the official UN OEWG website and on the GAROP website very soon. But the deadline is October 31st, so we want to be mindful of that. Our next webinar will take place on the 5th of September, and it will focus on the right to work and access to labor market in older age, with Consuelo Moreno, Fundación Oportunidad Mayor from Chile. And finally, a thanks to Bill, and finally, a huge thanks to the IFA for hosting this webinar and with their continued support.